Application is granted as read.
As the court pleases.
Yes. You say? Yes, Allah, he is online. Yes, Mr. Ebu.
Yes, my lord. My lord, the defendant, my lord, the defendant filed her final written address.
Yes.
My lord, the defendant filed her final written address.
Yes.
On the 12th of
Yes.
September 2025.
Yes.
Out of time, regularized the said process on the 14th of October 2025.
Yes.
My lord, for the kind consideration and determination of this honorable court, the defendant formulated only 2 issues.
Yes.
My lord, in reaction to the claimant's final written address, the defendant again filed a reply on points of law on the 1st of December 2025.
Yes.
My lord, may I humbly seek your leave to adumbrate for only 1 minute.
Yes.
Only 1 minute, sir. My lord, the claimant in his final written address made a heavy wager out of fair hearing.
Yes.
And the issue of economic downturn.
Yes.
As a reason.
Yes.
For placing the claimant on, my lord, the claimant stated that the reason given is false. My lord, our submission is this. That an employee
Mr. Ebu. Mr. Ebu.
Yes, sir.
It appears your network is not very clear.
Sir, I'm hearing my lord very well, sir.
Your addresses. Do you need to continue with adumbration?
Because Lord, I just want to supply one authority only the authority, sir. Yes, sir. Permit me, sir, to supply only the Supreme Court authority of 2025 on this matter. My Lord, the authority is the Supreme Court decision in the case of Damisa, D-A-M-I-S-A, versus UBA.
Yes.
2025, LPELR.
Yes.
80096 at page 13 to 14, paragraphs E to F. Yes, my lord. My lord, permit me to just read out. He said, indeed, a master is entitled to dismiss his servant from his employment for good or bad reasons, or for no reason at all. Yes, sir. He went further to say that in the circumstance, what determines the wrongfulness or otherwise of the plaintiff's employment is the contract of service and not any notion of fair hearing. My lord, based on all this, we humbly adopt our final written address and our reply on points of law as the summation of our argument in this matter. I humbly pray, my lord, to dismiss this suit for the reasons advanced in our written address.
Yes, you should make available that authority to your learned
My
clerk.
Lord,
That new authority, that
as it
this
comes
authority,
places, my Lord, I will.
supply it to your learned friend. Supply it to Mr. Umbe, the counsel for the claimant.
Yes, my Lord, I will. Yes, my Lord, I will. My Lord, for speed, permit me, sir, or authorize that I send it to him by WhatsApp.
Yes, you
I
can
will,
send
sir.
You communicate with him now through WhatsApp or through email. Yes, Mr.
As
Umbe.
it comes places.
Yes, he has finished now. That's why I asked you. Yes, 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 yes. On. Okay. Yes, 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 yes. Should be placed what? Okay. For that. Okay. Yes. Yes. Mm.
Sorry,
Yes.
my Lord, I'm sorry, sir. My Lord, I'm sorry. My Lord, I'm objecting. My Lord, I'm sorry, sir.
What is it, Mr. Ibu?
My Lord, I'm sorry, I'm objecting. My Lord, in adoption of final written address, adoption should be on something that is not in the address, not to re-argue your address in court. All he's saying now are containing his address. So he should adopt it. He should adumbrate based on what is not there. If it is there, my Lord, he cannot be allowed to re-argue.
He cannot adumbrate on what is not in the address. It is his address. What does adumbration means? Is to amplify.
To stress. Yes,
So
sir.
what are you saying? He
To
cannot.
amplify, to bring up some subtle points that are not contained in the address.
Yes, let's make
Yes, sir. Yes,
progress.
sir. Yes, sir.
Yes. 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 Yeah. Yeah. Thank you. Yeah, let me see what there. Did you fix any judgment on tariff on 22nd February?
That's what we
I mean,
have.
one.
Originating someone yesterday.
Okay. Okay, let's put this one. This case is hereby adjourned to 22nd day of February 2026 for judgment.
As the court places, my Lord, we are very grateful.
Okay, you are welcome.
My Lord, we are very grateful. My Lord, we have a humble application, sir.
Hey, what is that?
My Lord, we crave your indulgence most humbly,
Yes.
pending when situations will improve in terms of security. We humbly urge
Yes.
my Lord, pray my Lord to order that the judgment be delivered, we attend virtually, sir,
It's all
on
right.
the
The judgment
22nd of February.
Don't worry, judgment will be delivered virtually. Yes.
As the court pleases, my Lord, we are very grateful.
Huh? No, not January. I said February. I asked you of February.
22nd February, sir. Put ahead.
I did not say whole February. I said this week. I said 22nd February, and you said we have. Okay. It's not. You told me we have even. Sorry, counsel. We discovered that 22nd is a Sunday, so we are changing the date.
Yes, sir.
It will be 19th. February 19th. February 19th. February 19th, Mr. Ebu. February 19, 2026 for judgment. And it will be virtual. You can attend physically or virtually. Yeah. Between Eco Polling Institute and Pilgrim Nigeria Security Ministry. My Lord, the claimant in court, defendant is represented by Simon name. Richard. Your position, sir. Legal president of the appearance. Yes. 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 You say you have. I don't have that application. Have you served it on the when did you file it? It can't be in the file. You're supposed to file it 3 days to the time. You can't, it's your fault. It's not the fault of registration. You're supposed to file it 3 days. If you want your application to be in the first file, you must file it 3 days to the date when the matter is coming up. They have directive not to bring any application that was filed in less than 3 days to the time of the case. Yes, I don't have that application. What do we do? Well, I can stand down. Let them bring it. What's the next case? What's the next case? Case number NIL plus. Esther Barrow and Chief Gabriel Morgan. The claimant is present, my lord. The defendant is absent. Appearance. Yes. 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 Francis. AHAAIRI. This matter is for judgment. This is the judgment of the court. By the general form of complaint dated 8th day of November 2023, and filed on the same date, accompanied by statement of facts, witness statement on oath, list of witnesses, list of documents, and photocopies of documents to be relied on at the trial. The claimant claims against the defendant as follows. A. Arrears of salaries in the sum of 115,000 naira. B. Sum of 99,000 naira, being 3 months salaries in lieu of notice. C. The sum of 20 million naira being general damages for unlawful termination of claimant's employment by the defendant. D. Cost of this action assessed at 500,000 naira. Upon being served with the general form of complaint commencing this suit, the defendant filed a memorandum of conditional appearance and statement of defense out of time, which was deemed properly and filed and served by order of the court made on 23rd day of April 2024. In the statement of defense, the defendant denied the entirety of the claim of the claimant. On the 26th day of April 2024, the reply to stating on 26th day of April 2024, a reply to the statement of defense was filed by the claimant, which was improperly filed and served out of time on 28th day of May 2024. On the 3rd of December 2024, the claimant testified as CW1 in proof of her case. 3 documents were tendered in evidence through CW1 and were admitted in evidence and marked as exhibit CW1, CW2, and CW3. On the 27th day of February 2025, one Priscilla Bassi testified as CW2 in proof of the case of the claimant. No document was tendered in evidence through CW2. At the end of her testimony, CW2 was cross-examined and thereafter she was discharged. On 8th day of May 2025, one Adenye Asunta, Vice Principal Administration, testified in defense of the defendant. 5 documents were tendered through DW1. The documents were admitted in evidence and marked as exhibit DW1A to DW1E. The DW1 was cross-examined thereafter she was discharged. On the 16th day of October 2025, counsel for the parties adopted their final written addresses after deliberation. The case of the claimant. I will skip reading the case of the claimant. I will also skip reading the case of the defendant. I will also skip the submissions of parties. The defendant in their final written address formulated 6 issues for determination. The argument on the issues have been captured in the body of the judgment, while the claimant formulated 3 issues for determinations. The argument on the 3 issues have been captured in the body of the judgment. So I will skip reading the argument. I will go straight to the decision of the court. I have considered the processes filed by the parties, evidence adduced at the trial, and the written and oral submissions of counsel for the parties. The counsel for the defendant formulated 6 issues for determination, while the counsel for the claimant formulated 4 issues for determination. From the claim of the claimant, there are 4 reliefs being sought by the claimant. The relief A is for arrears of salaries in the sum of 115,000. Relief B is 99,000 naira 3 months salaries in lieu of notice. Relief C is 20 million being for general damages for unlawful termination of claimant's employment. And D, cost of this action, which the claimant assessed as 500,000 naira. In civil cases, the burden of proof is always on the party who assert a fact to prove same, because he whose assert must prove Section 131 to 133 of the Evidence Act passed. See also Are versus Adisa, Atane versus Amu, Obi Miami Bricks and Store Nigeria Limited versus ACB Limited, Ibrahim versus Jomo, and host of other cases cited therein. Therefore, in the case at hand, the burden of proof is, in the sense of establishing the case, initially lies in the claimant. The proof of rebuttal of issues which arise in the course of proceedings on particular matters which generally may shift from one party to the other and vice versa, so that if a party who has the initial burden to leave evidence on particular issues does so by showing prima facie, he throws the burden of rebuttal that the evidence upon the other party. He throws the burdens of rebuting the evidence upon the other party and vice versa as the case progresses. This general rule is enshrined in the maxim et quid affirmit non et quid res incumbent probatio. See also the case of Sawaru versus Zeruke. The burden of proof is not static, but it is divided between the parties. That is, it is swing as the pendulum swing. Whether the burden of proof has shifted will depend upon and must be related to the issue raised on the pleadings. See Adegoke versus Adibi. See also Logi Pest Impression Cleaners Limited. Logi versus Pest Impression Cleaners Limited. In considering the case put forward by the parties for resolution, this court will be guided by the extant rules of evidence and burden of proof. In the instant case, above eventual rules will guide the consideration of the case brought by the parties for resolution. Before considering the case of the claimant, I shall endeavor to deal with some preliminary issues raised by the pleadings and submissions of counsel for the parties. The first is that the defendant has, in the final written address filed before the court, argued that in the four reliefs being sought by the claimant, there is not that is seeking or praying for a declaration that the contract of employment of the claimant was wrongfully terminated by the defendant or unlawfully terminated by the defendant, as it directly shows by the claimant relief. According to counsel, the law is right that the court is not a Father Christmas nor a charitable institution, and as such, it cannot grant or it lacks jurisdiction or competence to grant relief not sought by a party. In support of this proposition, several decisions were relied upon by the counsel. Counsel for the defendant is of the view that the failure by the claimant to ask for a declaration that a contract of employment has been wrongfully determined or terminated by the defendant is fatal to the four reliefs being sought by the claimant. As according to counsel, the reliefs are ancillary. A reaction to the above submissions of counsel for the claimant insisted that the claims or reliefs sought by the claimant are substantive claims or reliefs and not ancillary as argued by counsel for the defendant. In resolving the issue of whether the four reliefs sought are ancillary, dependent on declaration which has not been sought, I shall refer to the definition of the word ancillary in the Black's Law Dictionary as quoted by the Court of Appeal in two cases, namely Adebayo David Alarapo and others versus PRP and others. Then the second case is Polaris Bank Limited versus Kashim Abdurrashid Olarewajo and another. In these two cases, the Court of Appeal adopted the definition of ancillary as given in the Black Law Dictionary edition at page 302, where it defines ancillary as a claim that is collateral to, dependent on, or auxiliary to another claim. Now, can the four reliefs sought by the claimant, which have been reproduced in the earlier part of this judgment, be tagged or said to be ancillary, or are they substantive reliefs standing on their own? Under Nigerian labor jurisprudence, a claim for unpaid for arrears of salaries, 3 months notice, general damages for unlawful termination, and cost of action are all independent causes of action because are all independent causes of action based on breach of contract. The reliefs do not require a prior or accompanying declaration that the termination was wrongful. The defendant's argument, as can be gleaned from the final written address, is clearly based on misconception of law. This is because the Supreme Court of Nigeria has consistently held that an employee is entitled to claim unpaid salary or wages owed under a contract of employment, regardless of whether the termination itself was lawful or unlawful. The pivotal question is whether the employer owes the debt for services rendered or salary accrued. See the case of Debono versus Federal Capital Development Authority. See also Dr. Ben O. Chukura versus Shell Petroleum Company Nigeria Limited. Therefore, an action claiming arrears of salaries, 3 months salaries in lieu of notice, damages and cost of action arising from breach of contract or employment and failure to pay wages and are enforceable through an action filed in that respect. There is no legal requirement that an employee must claim a declaration that the termination was wrongful before claiming arrears or unpaid salaries, damages, and cost of litigation. In Chief FSB Bakare versus Africa Continental Bank Limited, the Supreme Court affirmed that it is the inherent right of every person in this country to seek any remedy or relief available in our courts for the relief of any injury done on or infraction of his civil rights and obligations. Therefore, the claimant in this case is free to claim unpaid salaries, is free to frame her claim based on the relief sought. In law, claims for unpaid salaries and claims for wrongful termination are distinct causes of action. The claimant may pursue unpaid wages without challenging legality of termination. In Dr. Ben Chukura versus Shell Petroleum Nigeria Limited, the Supreme Court considered claims for both wrongful termination and unpaid entitlements, but treated them as separate issues. The court held that even where the termination was wrongful, the employee was entitled to salary in lieu of notice and terminal benefit as independent contractual rights. It is pertinent to point out that the relief claim must be something which would not be unlawful or unconstitutional or inequitable for the court to grant. It should also not be contrary to the accepted principles upon which the court exercises its jurisdiction. See the case of Guarantee Trust Bank Limited versus Hani. What the defendant has done in arguing that the claimant ought to have asked for a declaratory relief was to advise the claimant to frame his relief in the way and manner the defendant wants the relief to be framed. The defendant has no such power or right to do so. The duty of the defendant in an action where the claim is to answer to the claim of the claimant in defense and not to dictate to the claimant the type of relief to seek from the court. He can also counterclaim if any. It is to be noted that a declaration that the termination was wrongful will become relevant in situation where the claimant seeks reinstatement or declaration that the employment still subsists, or the claimant seeks damages for loss of future earning or other consequential losses arising from the wrongful dismissal, or where the claimant challenges legality or validity of the termination. In the case at hand, it is a different ballgame where the relief sought are simply for unpaid salaries, 3 months notice in lieu of notice, and the cost of action. In this situation, such a declaration is not a prerequisite. The claimant is entitled to pursue relief sought on their merits, and the dependent duty is to file defense in answer to the facts stated addressing the substance of the claim, rather than challenging the claimant's choice of remedies. In view of the foregoing, I have found the objection of the dependent to be frivolous. The relief sought by the claimant as being ancillary, requiring making claims for a declaration for the court to have jurisdiction is untenable and is hereby dismissed. Another very crucial issue that needs to be addressed is the objection of the defendant to the effect that he is not the proper person to be sued in this suit because access group of schools, but the access group of schools. Counsel for the defendant has argued that Exhibit C2, DW1A, DW1B, and DW1C, and DW1D clearly shows that access group of school is the employer of the claimant, as there is nowhere in the exhibit referred to where the name of the defendant was mentioned or stated. The defendant's argument was hinged on the assertion that access group of school is a subsidiary of access schools, which is an incorporated entity having power to sue and be sued. This assertion was vehemently denied by the claimant, arguing that access group of school is not a subsidiary of access school. The claimant insisted that she was employed by the defendant through access group of school, a non-juristic person. The defendant's argument that it is access group of school that is to be sued in this case clearly raises the fundamental issue of the fundamental legal principle of legal personality and the proper identification of a dependent in an employment contract. It is pertinent to note that the defendant was sued as Chief Gabriel for modem doing business under the name and style access group of school. The claimant has insisted that she was employed by the dependent through the access group of school by the position of the dependent that access group is a subsidiary of access school, possessing a separate legal entity from the dependent, thereby making access group of school as appropriate dependent in this case. In law, for an entity to be sued, to sue or be sued, it must be a legal person. This means that it must be either a natural person, an individual, or an artificial person, a corporate body, or an incorporated trustee recognized by law. An incorporated company, for instance, is a distinct legal entity separate from its members, directors, or shareholders. See the case of Solomon versus Selmon. Therefore, for legal personality of access group of school to be established, the dependent is required to produce the certificate of incorporation of access group of school, which is the recognized evidence to prove legal personality. See the case of UBA PLC versus Feb Oppo Nigeria Limited. The capacity to sue and be sued is fundamental, and for an incorporated company, this capacity is derived from its registration. The dependent has not tendered the certificate of incorporation of access group of school. This means the dependent has woefully failed to prove his assertion on the issue of access group of school being a subsidiary of access school. The dependent, having been sued as doing business under the name and style of access group of school, is therefore a proper dependent in this suit. It is also pertinent to note that even if access group of school is a business name, even if registered, it is not a legal personality. It is not a legal entity capable of suing or being sued in its own name, in its own right. Rather, it is the proprietor that is the appropriate party to be sued. And in this case, Chief Gabriel Omodium that is the proper party, being the proprietor of access group of school. In this case, the defendant having been sued as doing business under the name and style access group implies that the defendant is a proprietor of that access group of school, and the business name is merely a trading style, not a separate legal entity. When an individual does business under a name and a style, generally in such a scenario, the individual proprietor bears all liabilities and obligations of the business. The fact that Access Group is alleged to be subsidiary of Access School is irrelevant, since Access Group of School itself is not proven to be an incorporated entity. Having found in this statement that Access Group of School is not a legal personality, as the defendant who alleges that Access Group of School is subsidiary of Access School has not proved that assertion. Therefore, I am left with no option than to hold that Access Group of School is not a legal entity capable of suing or being sued. It is interesting to note that the claimant has sued claimant as dependent in this case, suing as doing business and style under the style and name of Access Group of School. And the defendant has not denied that he was not doing business under the name and style of Access Group of School. This finding means that the defendant is a proper party in this suit. Another piece of evidence to make defendant being proper party in this suit is the evidence of the claimant to the effect that when the payment of her salaries were irregular, she approached the defendant's wife so as to prevail on the defendant to pay the claimant her unpaid salaries. But the defendant, instead of paying her unpaid salaries there and then terminated her employment orally and asked her to leave the premises of Access Group with immediate effect. This piece of evidence has not been contradicted by the defendant, as the defendant did not testify or adopted his written address on oath, and the evidence of DW1 is not capable of establishing what transpired between the claimant and the defendant on 11th day of September 2023 at Atimbo branch of Access Group of School, where the claimant works the day the defendant terminated her employment when she reported for duty. I am in agreement with counsel for the claimant that the evidence of DW1 on the issue of termination of employment or that what transpired between the defendant and the claimant is hearsay evidence by the provision of sections 37 and 38 of the Evidence Act as amended. This evidence is inadmissible and I hereby reject and I hereby hold that the evidence of DW1 is not admissible. The submission of counsel for the defendant in reply to the address of the claimant to the effect that the testimony of DW1 is the testimony of our official capacity as by principal admin and cannot be designated as hearsay evidence is also misconceived. The reason being that for any evidence given in official capacity, it must be evidence of the relevant officer. In this case, the evidence of the claimant regarding termination of her employment by the defendant is evidence that transpired between the defendant and the claimant. Therefore, for any rebuttal to have any weight, it must be evidence of the defendant himself who is involved. Furthermore, Section 126 of the Evidence Act as amended provided that oral testimony shall in all cases be direct. It must be testimony of a person who saw or had or perceived the event under scrutiny. In this case, there is doubt that if the event of 11th of September 2023, there is no doubt that the event of 11th September 2023 took place in the absence of DW1, who was at a far away at number 1 Kadana School Road, State Housing Estate, Calabar, which is not the same with Atimbo, where the incident took place. Another reason why the testimony of DW1 will not have any evidential value is the fact that Access Group of School is not a legal entity, as the defendant has willfully failed to adduce evidence establishing that it was incorporated in accordance with the Companies and Allied Matters Act, which would have closed it with legal personality, the sue and be sued, which would have also made DW1 an agent of Access Group of School to have capacity to testify in official capacity. In this case, DW1 is employee of the defendant, like the claimant, and the event on which there is dispute did not took place before DW1. Rather, it happened before the defendant himself and the claimant, but he failed and refused to appear before the court to testify or debunk the claim of the claimant, thereby suggesting that he does not have contrary facts to tell the court. The case of Epiazo versus ACB Limited is referred. Support this view that testimony of employee of a company to have any weight, it has to be testimony of officer whose job description relates to the issue. In this case, the defendant is not a company to enjoy the exception created to the doctrine of hearsay evidence when it relates to companies. In the Ekpeazu case, the Supreme Court rejected evidence of bank clerk that alleged that the appellant was a partner. The appeals court held that the singular testimony is inadequate. In Ogugua versus MS Transport Limited, in this case, the testimony of a company business manager was not given any weight as he was neither a mechanical nor an automobile engineer, which is the relevant evidence needed. In Tupobo versus Adelagun, the Supreme Court considered testimony of secretary as specious and clearly unreliable. In Jellico Limited versus Oeli Boy Technical Services Limited, the Supreme Court upheld the contention that where the conduct and affairs of a particular officer in respect of a specific transaction is in dispute, it is that officer who should be called to explain the transaction and not an officer who never had anything to do with the transaction. It is apparent from these judgments of the apex court that a company which opts to get its staff who was not directly involved in a transaction to testify has testified risk the testimony not having any evidential value, as in this case. In the case at hand, the conduct in question is that of the defendant and not DW1. In the circumstances, the appropriate witness to testify is the defendant himself and not DW1, who was not present when the event that led to the termination of claimant's employment took place. Having dealt with the preliminary issue, I shall now turn to the determination of whether the claimant has, by the evidence adduced before the court, proved entitlement to any of the relief sought before the court. Relief 1 is for payment of the sum of 115,000 naira as unpaid salary. The parties are at event that claimant was employed as per Exhibit C2, which is the same with Exhibit DW1E, with effect from 12th day of April 2023 on salary of 33,000 naira per month. By the Exhibit DW1C, the claimant accepted the offer and assumed duty accordingly. According to the claimant, she carried out her duties diligently from the date of her employment, i.e. 12th of April 2023 till 11th of September 2023, when the proprietor of Access Group of Schools, the defendant in this suit, came to school enraged and told the claimant that she has been sacked and that she told her to leave the school premises immediately. The claimant further averred in her pleading that from 12th day of April to 14th of September 23, she was only paid a total sum of 83,000 naira in 3 installments of 17,000 and 33,000. For 6 months, she served the defendant, which is not up to the sum of 198,000, leaving the sum of 115,000 as unpaid. In his defense, the defendant denied being employer of the claimant and stated that the employer of claimant was Access Group of School, a subsidiary of Access School. This assertion is clearly wrong, as the defendant is the employer of the claimant, as Access Group of School is not a legal entity, but an appellation under which the defendant carried out his business. It is interesting to note that the defendant has, in his pleading, stated that the claimant was paid salary as and when due when she was reporting for duties regularly. That is that in the months of July, August, and September 2023, she failed deliberately to diligently carry out her assignment, teaching duties, as she displayed high level of non-satisfactory performance of her assigned duty. It was also alleged that the claimant absconded from her duties and has not served the dependent with her resignation letter based on the terms of engagement. The claimant was on 14th of August 2023 issued with a query due to non-performance, which she responded on 15th day of August 2023. See Exhibit DW1D. By the paragraph 10 of the statement of defense, it was about that the claimant never worked for access group of school for 6 months, but the claimant was paid 2.5 months salary for the period 15th of April 2023 to 30th June 2023. According to the defendant, it was lackadaisical offensive attitude of the claimant in discharge of her assuming teaching in her assigned teaching duties, which kick-started mid-July 2023 and lingered till 11th day of September 2023, when she absconded from her duty post. That made claimant not entitled to any arrears of salaries, as she has not worked for the months of 12th of July 2023 to 12th of August 2023 and 12th of August 2023. As required by the terms and conditions of her temporary appointment. According to the defendant, the attitude of the claimant coming to work whenever she pleases as an intolerable gross misconduct. I have carefully scrutinized the position of the parties regarding Exhibit A on the claim for the sum of 115,000 as arrears of balance of unpaid salaries for 6 months, which claimant alleged served the defendant. The defendant on his part admitted that it had the claimant 2 months salaries, 2.5 salary. For the period the claimant served the defendant has categorically stated that the sum of 98,000 naira paid to the claimant as salary is for the period from 14th of April to 30th day of June 2023. The defendant tried to justify paying the claimant for 2.5 months because, according to the defendant, the claimant misconceived herself for not coming to work as the defendant tried to justify paying claimant the 2.5 salaries because, according to the defendant, the claimant misconducted herself for not coming to work at appropriate time and closing as she wishes. Absenting herself from work in some days. The defendant, in attempt to prove claims of misconduct, tendering in evidence Exhibit DW1A, which is photocopies of some pages of attendance register. This document was not tendered as a whole. It was only pages which the defendant want to rely on, omitting those pages that the defendant does not want. Exhibit DW1A being a document, it has to be tendered in total unless there is justification for not tendering the whole of the document because it is bulky or it will be difficult for difficult for the whole document to be tendered. The defendant has not told the court why the entire document in Exhibit C DW1A could not be tendered and why the original is also not tendered before the court or reproduced for examination by the court. In view of my observation above, Exhibit CW1 being photocopies of exhibit of pages of register and not entire register or extract from the register, it is not capable of proving anything before the court, as it is weightless like feathers of a fly. In view of the foregoing, I came to the conclusion that Exhibit DW1A does not have any evidential value. Does not have any evidential value. It is hereby discountenanced for the purpose of this judgment. Another reason why credence cannot be accorded to the alleged claimant's absenteeism herself from duty or reporting late and closing early is that these acts amount to gross misconduct for which the defendant has power to punish, but choose not to. From the facts as revealed by the pleadings, the claimant was employed with effect from the 1st day of April 2023 as per XBCWP, and her employment was terminated by the defendant on 11th of September 2023. From 12th day of April 2023 to 11th of September 2023, the claimant has served the defendant for a period of 5 months only and not 6 months as abided by the claimant. This means the claimant ought to have been paid 5 months salary for the period she served the defendant. The defendant, having admitted paying only 2.5 months, is liable to pay the claimant the balance of the 2.5 month salaries. The claimant served the defendant for 5 months as found by the court, and the paid salary of the claimant is put as the sum of 33,000 naira. If this amount is multiplied by 5 months, it will amount to 165,000 naira. And if the sum of 83,000 naira paid already paid to the claimant for 2.5 months is deducted from the total amount the claimant is entitled to as her salary, the balance will be the sum of 82,000 naira. In view of this finding, the claimant is only entitled to the sum of 82,000 naira and not the sum of 115,000 naira as claimed. If they succeed only in the sum of 82,000 naira, I shall now deal with the relief B and C together because they are related and interwoven. In relief B, the claimant claimed for the sum of 99,000 naira being 3 months salaries in lieu of notice. While in relief C, the claimant is praying for an order directing defendant to pay the sum of 20 million naira as damages in favor of the claimant for unlawful termination of claimant's employment by the defendant. The counsel for the defendant in the final written address of the defendant has strenuously argued that the claimant, whose contract of service was not having statutory labor but that of master and servant relationship governed by a relationship of the parties, the termination cannot be declared to be unlawful, illegal, or null and void. Counsel continued his submission that the claimant has only to place before the court terms and conditions and to prove in what way the terms were breached by the employer for a declaration to be granted. Council relied on the several decisions of the Court of Appeal and the Supreme Court in support of his submission. The counsel for the defendant has also argued that the claimant was only able to prove two ingredients of wrongful termination, but failed to prove the two other ingredients, i.e., counsel further argued that the C2 did not provide for 3 months' salaries in lieu of notice or payment of 3 months' salary. Rather, the claimant is the one that is required to give the defendant 1 month salary, 1 month notice, or 2 months salary in lieu of notice in the event that the claimant decided to terminate the contract of employment. According to counsel, some mode and manner claimant's employment can be terminated is left to the discretion of the defendant. Counsel also argued that claimant by the XBDW1C accepted Exhibit C2, therefore she cannot complain favorable terms and unfavorable terms of Exhibit C2. Counsel submitted that parties are bound by the terms of the contract, and no court of law is empowered with the jurisdictional competence to rewrite the agreement of parties, and a party cannot and would not be allowed to resign from a contract or agreement just because he later found out that the condition of service of contract agreement are not favorable to him. To support his submission, counsel relied on the case of Enyon and other versus DB and another. It's also submission of counsel that Exhibit C2, what is not actually agreed upon between her and the defendant, to say that she ought to be given 3 months notice or 3 months salaries in lieu of notice, or that what is good for the goose is also good for the gander, or that she ought to be given 1 month's notice or 2 months salary in lieu of notice. Counsel submitted that the claimant, defendant, and this court are bound by Exhibit C2 in determination of this suit, and this court cannot go on a voyage of discovery to improve into parties' contract what was never agreed by the parties, or rewrite the contract of the parties for the parties, as Exhibit C2 is explicitly and unambiguous. For counsel for the claimant, the termination of claimant's employment on September 11 is wrongful. Counsel submitted that notice provided for Exhibit C2 is 1 month salary in lieu of notice, or 2 months salaries that claimant is entitled to claim for damages for wrongful termination. It is clear to me that 2 reliefs under consideration raise issue of payment in lieu of notice for termination and payment of damages for unlawful termination. In law, contract of employment may be determined principally by termination or by dismissal on peculiar facts. Basically, such both termination and dismissal may be governed by the facts basically in such both agreement of the parties or a combination of some or all of these, and then resolve upon the contractual relationship between the parties. Generally, employment contract is premised on an agreement between the parties that is to say employer and employee, who seeks to retain the services of another employee, effectively putting 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 the employee under their payroll. Like every contractual relationship, any of the parties can decide to bring this relationship to an end at any time, or it can be brought at an the express agreement entered into by both parties is an agreement contract usually provide for the procedure for the termination of the contract. However, the law is that an employer has right to dismiss his employee whether or not it proved in the contract of service. It is contained in the contract of service. See Simon and Asabe versus Bank of the North. In the present case, we are concerned with termination of claimant's employment. The claimant has vividly explained how his employment was terminated by the first defendant verbally on 11th day of September 2023. See paragraph 4 to 13 of the statement of fact. The evidence of the claimants on how her employment was terminated only by way of the evidence of the claimant on her employment was that her employment was terminated orally by the defendant has not been contradicted or controverted, as there is no credible evidence adduced by the defendant to challenge the said evidence of the claimant regarding her termination. This is because, as pointed out earlier in this judgment, the testimony of DW1, the witness brought by the defendant to give evidence on his behalf, is hearsay evidence which is not acceptable in law for not being first-hand information. The defendant must support evidence to support his affirmation. Where this is not done, the defendant is deemed to have abandoned his defense. See Okechukwu versus Okafor and Tenu and others versus Bello and others. The failure of the defendant to adduce evidence to contradict, controvert the claimant's evidence means that the evidence of the claimant is unchallenged and the court is entitled to make use of it. It is right law that unchallenged or uncontradicted evidence by the adverse party is good to be acted upon by the court, unless it is either irrelevant or palpably false or worthless by itself. See Cameroon Airlines versus Mike Otutuzu. See also Ishola Lawson versus Apani Continental Company, Nigeria Limited. See Omorobe versus Lawani. In the absence of cogent credible evidence from defendant, cast doubt on the evidence of claimant, I accept the evidence of CW1 as the true facts of this case. This means I accepted the narration of the claimant that the defendant terminated her employment orally on the 11th of September 2023 without any notice or payment in lieu of notice for termination. Ordinarily, termination by notice is by agreement of the parties, or at least that which the law is prepared to regard as their agreement by implication. This means that where there is a written agreement of the parties on termination, the provisions of the agreement must be given effect by the parties. However, in the case at hand, by the Exhibit C2, which is the letter of employment of the claimant, has made provisions for giving 1 month notice or payment of 2 months salary in lieu of notice by the claimant. where the claimant decides to end the relationship. It is interesting to note that Exhibit C2 is silent and did not make provision for termination of dependence employment. This means that, as pointed out earlier in this judgment, where agreement of parties is silent, then the absence of the specific provision is an employment contract detailing the employer's obligation to give notice both to give notice or pay in lieu of notice when the termination of employment that does not automatically mean that the employer can terminate without such notice or payment in lieu of notice. It is right law that employment relationships are governed not only by the express terms of the contract between the parties, but also by statutory provision and judicial pronouncement, which often imply or mandate certain conditions where the contract is silent. Primarily, the Labor Act is the foundation statute governing employment in Nigeria. See Section 11(1)(a) of the Labor Act. This provisions applies equally to both employer and employee. Subsection 2 of Section 11 further specifies the minimum notice required depending on the duration of the contract. The notice, the required period of notice as stated in Section 11 are that for 1 day contract, 1 day notice. For 1 week, where the contract has continued for more than 3 months, but less than 2 months, but less than 2 years, is 1 week. For where the contract has continued for a period of 2 years, but less than 5 years, 1 month. One month's notice is required where the contract has continued for a period of 5 years or more. This statutory provision serves as a baseline. While parties are free to agree on longer notice period, they cannot contract out of this minimum statutory requirement to the detriment of the employee. Therefore, where written agreement is silent on the employee's notice period, the employer is still bound by the minimum notice period stipulated in Section 11 of the Labor Act. The principle of payment in lieu of notice is also well established, as it is implied in contract that is silent on notice or payment in lieu of notice, as in this case, the Supreme Court in Skybank PLC versus Adegun, for instance, has addressed the mode of payment of salary in lieu of notice, affirming its validity as an alternative to actual notice. Nigerian courts have consistently held that where a contract of employment provides for a mode of determination, that mode must be followed. However, where the contract is silent or ambiguous regarding one party's obligation, statutory provision will fill in the gap, as in this case, Inshena Securities Limited versus Apropac. The Supreme Court emphasized that the effect of a contractual contract of service which provides for the mode of termination, while this case primarily deals with situation where a mode is provided. The underlying principle is that employment contracts are not entirely at the whims and caprices of one party, especially the employer, due to the protective nature of labor laws. The Court of Appeal in Shuaibu and another versus NBC PLC reiterated the position of the law where parties to the employment contract mutually agrees that the condition to determine same is going to be of notice or payment in lieu of notice. Even in situation where contract explicitly state conditions for one party but silent on the other, as in this case, the court will imply a term of reasonable notice or more definitely apply to statutory minimum provided by the Labour Act. Furthermore, Section 7.1 of the Labour Act defines specifying the terms of employment, including the appropriate period of notice given by party wishing to terminate contract. The absence of this the absence of these details in Exhibit C2 amount to breach of Section 7 of the Labour Act. It does not negate the employer's obligation under Section 11. Therefore, the fact that the written agreement Exhibit C2 only specifies the employee's notice period, 1 month or 2 months salaries in lieu, and is silent on the employer's corresponding obligation, does not grant the employer the right to terminate without notice or payment in lieu. The employer is still legally bound by provisions of by the provision to provide at least the statutory notice period as stipulated in Section 11 of the Labour Act, or pay salary in lieu of notice of any termination without adhering to the stipulation in Exhibit in Section 11 of the Labour Act, or pay salary in lieu of notice. Any termination without adhering to this statutory minimum will be wrongful. The party seeking to determine the contract simply need to give adequate notice as prescribed under the contract, so as to deal and implied by law the right to practice the right of practice to contract employment to terminate it by notice, where no contrary intention exists, is fundamental. This right is underscored by the rule that where a contract is silent regarding the right of the parties to a contract employment to terminate it by notice where no contrary intention exists is fundamental. This right is underscored by the rule that where a contract is silent regarding notice which is to be given to terminate it, the term will be implied. That is reasonable notice. It is to be given. See the case of Abu Kobo versus Africa Timber and Plywood Limited. See also Daniel versus Shell BP Petroleum Company. See also Calabar Cement Company Limited versus Daniel. Thus, the court still will read into any such contract a provision that a contract is determinable with reasonable notice. Going by the above exposition of the law, the claimant in this case, having been terminated without notice or payment of salary in lieu of notice, it will be in line with Section 11.2 of the Labour Act. From all I have been saying above, the claimant is entitled to payment of only 1 week's salary in lieu of notice, as contained in Section 11 of the Labour Act, since there is no such provision in the contract of employment at C2. The parties here have a master-servant relationship. This means that the court cannot make a finding that termination of claimant's employment by the defendant is illegal or unlawful or null and void, as that does not arise. The law is settled that in master-servant relationship governed by common law, the court cannot order specific performance or order the reinstatement as the court does not impose employer or employee relationship. The court can make a finding like in the case that termination without giving notice or payment in lieu of notice is unreasonable or wrongful, but not illegal, null and void. It is also the law that the court cannot set aside a wrongful act by employer who in Nigeria, the law has vested in employer with right to terminate employment of his or her employee, even where such right was not contained in the agreement. However, in terminating employment, the employer is under an obligation as per Section 11(2) of the Labor Act to give notice to the employee of such termination or pay salary in lieu of notice for period of notice. Therefore, the failure of the defendant to give notice to claimant in this case has rendered the termination wrongful as it constitutes breach of contract. The position of the law as wrongful termination of employment in any master-servant relationship which is purely contractual and devoid of statutory labor was clearly articulated in Oyibo versus UBN PLC. The Supreme Court reiterated that such a relationship governed strictly by terms of contract and employment. The employee's right to hire and fire is largely effective. Similarly, the principles applicable to the termination of the termination Similarly, the principle applicable to the termination of the master and servant relationship has been consistently upheld in the case of Obanye versus Union Bank, Eze versus Unizip, Wejife versus IGP, and others. These cases have found that the primary consideration is the contract of employment, where the contract specifies a period of notice for termination or payment in lieu, and the employer complies with this, the termination is valid and cannot be deemed unlawful. However, where the termination of the employment of an employee by the employer in a master and servant relationship will be wrongful, and the remedy available for such wrongful termination was expressly discussed in UTC Nigeria Limited versus Peters. The Supreme Court clarifies that a termination the most common breach is the failure to give agreed notice or to pay salary in lieu of such notice. In such scenario, the employee's claim for unlawful termination is essentially a claim for breach of contract. The remedy available to an employee whose employment without statutory labor has been wrongfully terminated is generally limited to damages. These damages are typically the same as salary, and the employee would have earned during the contractual notice period. The court do not usually order a settlement with specific information of the contract of employment in such cases, as it is a fundamental principle that court will not compel an unwilling master to keep an unwilling servant, nor vice versa. The rationale is that a contract from the above exposition, it will be correct to say that the claimant is not to claim for damages in the sum of 20 million. This claim, there is no evidence in proof of the claim for 20 million damages. The last relief, which is the cost of action, is assessed at 500, which the claimant assessed by himself at 500,000 naira. The principal relevant issue under consideration has been laid down in a number of cases, thereby becoming a certain law that post follow event, i.e., where issue of cost was not raised in the writ as a claim before the court, is granted at the discretion of the court and does not need to be proved strictly as in proof of special damages. It is at the discretion of the court upon delivery of judgment to award the cost to the successful party. In the case at hand, the issue of cost was raised by the claimant as a separate relief. This means that being specifically pleaded, it is a special damages claim that must be proved strictly. The claimant has not adduced any evidence in proof of this assertion. However, the claimant having succeeded in fact is entitled to cost to be assessed by the court. Circumstances of this case, the claimant is hereby awarded cost in the sum of 400,000 naira. From all I have been saying above, the claimant has partially proved his case, claim, and is entitled to judgment as follows. The claimant is entitled to arrears of unpaid salaries in the sum of 82,000 naira. 82,000 naira. The dependent is hereby ordered to pay the said sum amount to the claimant. The claimant is also entitled to be paid 1 week's salary in lieu of notice. The dependent is hereby ordered to pay the claimant I'm sorry, I forgot to do the calculation to get the 1 week salary. Let me quickly. The claimant salary is 33,000 naira, and we have 4 weeks in a month. If it is divided by 4 weeks, we will have each week the dependent will be entitled to 8,250 naira. Therefore, the claimant is entitled to be paid 8,250,000 naira as 1 week salary in view of notice termination of his employment. The claimant is also entitled to cost assessed in the sum of 400,000 naira. All monetary aspects of this judgment shall be complied with within 2 weeks from the date of this judgment, failing which 10% interest, simple interest, shall apply per annum. Judgment is hereby entered accordingly. Yeah, okay. Yeah, welcome. What's the next one?
This is standard, this
Yes,
standard
sir?
written address for the case that was standard for the adoption.
Put them in the file. What's the next case? What's the next case?